All right, last topic of the day. Got upset some Caymanians. Ask me if I care. I need to have a button that I can press says, "Do you care?" And then I can say, "Nope, don't care." All right. Well. Some of y'all again don't have no sense, and I hate to tell you, but if you ain't got no sense around you, we gonna have to sort you out. Someone posted, and someone sent it to me on one day last week. I think it might have been Friday. That there was some post and some discussion about an individual's eligibility to run for public office. Now, I don't know why your heads be taking y'all, but clearly it does. And y'all look like you not got no sense. Now, the person screenshot this and sent it to me saying that, let me show y'all now. Somebody wants to sue somebody. I don't even know who they're talking about and who they're planning on suing. Like, I'm not really entirely clear on that. But before you talk about suing people and exposing your lack of understanding, perhaps what you should do is educate yourself a little bit. Okay? So this is what it says. Time to sue the rumps off of some bruts that has been messing with me. Some brutes. Oh, sorry. I will take your friggin' pensions and build my cat sanctuary. At first, when I saw this cat sanctuary, I thought it said, I was reading cabinet secretary. I don't know why my brain was saying that, but I was like, you're going to sue the cabinet secretary? I'm like, what? Anyway, cat sanctuary. Get your lawyers because my writs are ready. I warned them, but they never listened. Okay. Then they have supplied a clean police record to say that this is to certify that as of July 14th, let me open it up on the next screen. Can't really say that. 2023, there are no convictions recorded in the criminal database of these islands against the bearer, Carrie Rosita Whitaker, date of birth, possessor of a CYM passport number. Now, honey child, I don't know why you're putting this up there with your passport number fully disclosed. That kind of is a dumb thing to do, actually. But I guess you're not worried about anybody stealing your passport. But anyway, and people have asked me if I could please address this. Okay. I believe that this centers around the point that Carrie wants to run for public office. And I suppose the question comes up about whether or not an individual who has a previous conviction but now can demonstrate a clean police record is eligible for public office. I don't even know why this is, quite frankly, a point of debate or discussion. But I think what this is really all about is it demonstrates a fundamental lack of understanding. And I am not here to, try to make anybody feel bad. I'm just here to divulge the facts as they are. If you have a police record, and I'm going to encourage you to read your Constitution. Not only should you read your Constitution, but you should also read relevant case law that might be very, very specific to your type of a situation. Don't post this stuff. I think it was a public post. I don't know. Don't post this stuff on public platforms like Facebook and threaten to sue people. Again, I don't know who was going to be sued, but I would not recommend doing it and then having people in this community talk about how you don't quite understand what's going on. Carrie says she wants to run for public office. She has the choice to submit her $1,000. They need to increase that fee, by the way. I'm just saying. Run for public office, and they will tell you whether or not you're eligible. Anybody can say they want to run for public office, and anybody, I suppose, in theory, can find $1,000 and run, put forward their name. Well, that doesn't mean that you're eligible to run for public office. There is a difference. Your eligibility will be questioned or challenged by the elector's office, the supervisor of elections, who will be Mr. What's his name now? Mr. Oh, Lord, have mercy. Wesley Howell. That's his job. What I would invite you to do, though, before you make yourself look silly and before you waste money running for elected office, you need to go read case law. Okay? This is where, folks, you can pick sense from nonsense. Pay attention now. Class is going to take a bit of a legal turn this morning. Okay? We done talked about a lot of other things. However, now this morning, we are going to discuss what is required for you to run for public office if you have a particular type of conviction. I've said it on this show before. I thought it was pretty crystal clear, but I'm going to say it again. You are ineligible to run for public office if you have a dishonesty conviction. The Constitution does not even say that you have to spend a day in jail. So theoretically, you can have a conviction that you never go to jail for, and you will still be ineligible because the nature of the conviction, you will be ineligible to run for public office. Exhibit number 1, Exhibit A, George Ebanks. Okay? George has a conviction for falsifying a document and for fraud. What that means is that he can never, and when I say never, I mean never, ever, 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 never, never, never run for public office. There's no exemptions. Okay? It is what it is. He didn't go to jail for that offense. The courts gave him a slap on the wrist. They said, don't do it again. Stop forging people's signature and stop lying to immigration. It's still a dishonesty conviction. Somebody said, did Carrie go to jail? Yeah, she served jail time. I mean, I think that's pretty common and wide knowledge. It seems to me, based on what is presented here, is that she has a spent conviction, which means that you can get a clean police record. You know what's shocking to me is people don't understand what a spent conviction even means in the real world. So yes, you can apply to have convictions 10 years later taken off your record so you can get a clean police record. The primary reason for that is for you to be able to find employment opportunities, perhaps even travel. However, you know, when you travel into the US and there's a little question there, you apply for a visa, whatever, have you ever been convicted of anything? Even though it's a spent conviction, you can't say yes or you can't say no to that. You know, you better answer it truthfully. Now, here's the thing. Spent convictions don't apply to certain things. Exhibit B, you go to court and you get convicted of assaulting a woman or whatever. You have in the past spent convictions, convictions that weren't recorded. All of that becomes live and has to be brought to the attention, if you're found guilty, has to be brought to the attention of the court. What does that mean, folks? That means that those things actually never really ever go away. For the purposes of you getting employment and perhaps being able to travel overseas, you can have a conviction spent and get a clean police record. For the purposes of the elections law, it stands just like it stands in court. You don't believe me? This is why y'all need to avail yourselves of something called the law. It's very simple. Super, super simple. There is a case exactly on point. Mario Rankin has a conviction for a dishonesty offense. He ran or tried to run for public office. He was challenged and he lost. Y'all need to read what that case said. I'm going to bring it up here. Law class is in session. Constitutional Law 101. All right. Here we go, good folks. This case was brought back in 2017 during the general election. Supervisor of elections against candidate X. Everybody know candidate X was Mario Rankin. There's no, not a state secret. Had QCs representing the Solicitor General's office, Mr. Graham Hampson, and Shuluka Tumala, attorneys at law for Hampson Company. The judgment disqualification for election to membership of the Legislative Assembly on the grounds of convictions for dishonesty, whether the respondent spent convictions and rehabilitation under the Rehabilitation of Offenders Law serves to avoid the qualification. This, folks, is where you need to read. Do not post foolishness on social media about you got a clean police record and you know that your conviction has been spent for dishonesty offense when there is case law on point. Caymanians, stop making yourselves look stupid. Okay? Even if you're stupid, keep your damn mouth shut and don't remove any doubt around the community that you're stupid. Okay? This is it now. I don't want to have this conversation. I'm having to have this conversation because y'all not paying attention, you're not reading, and you're not learning. Some of y'all brains need to be spent and recycled and start over. Okay? The very question is, can you be disqualified to be a member of the Legislative Assembly, now it's Parliament, on grounds of a conviction for dishonesty when the conviction has been spent? Huh? You couldn't get more closer because, in law, sometimes you find a case that's 80% similar fact scenario. Not exact. So you're going to argue those differences to try and win your case. This is almost you couldn't get any closer. Same conviction dishonesty. Does a spent conviction count? Yay or nay? It's only 22 pages, this judgment, and I will gladly let anybody have a copy of it that needs to have a copy of it. Okay? So they go through the different sections of the law, what happened, the duties and responsibilities inside of the supervision of the nomination process, yada, 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 section 29 of the law, the respondent having been nominated and the applicant having had reason, as further explained below, to believe that he's disqualified under section 29A1 of the elections law, yada, yada, yada. Question for resolution. This is what section 62(1)(e), subsection 1 of the Constitution says. No person shall be qualified to be elected as a member of the Legislative Assembly who, subsection E, subject to subsection 2, is serving or has served a sentence of imprisonment by whatever name called exceeding 12 months. Let me pause. So that's one. If you get convicted, if McKeeva Bush gets convicted of rape and he gets a sentence of more than 12 months, okay, that was imposed on him by a court, all right, is serving or has served a sentence of imprisonment by whatever name called exceeding 12 months, you are ineligible to be an MP in this country. All right. That's part of the equation. The other part of it, because some of y'all say, well, we have an MP who was convicted of drugs, back in his youth. How can he be an MP? He was never sentenced for exceeding 12 months. Maybe he got 9 months in jail. I don't know what he got. That's why he's an MP. And you, the people, knew his history and you put him in there. So, obviously you're giving him a second chance. It goes on. In addition to that, has been, now listen to this. Let me continue reading. Imposed on him or her by a court of any country or substituted by competent authority for some other sentence imposed on him or her by such a court, or is under a sentence of imprisonment, the execution of which has been suspended. Y'all understand that? Even if you get a suspended sentence in excess of 12 months, you become ineligible. Or, now this is the part that's relevant to this particular case, or has been convicted by any court in any country of an offense of dishonesty. Let me clarify this. I don't want to have this conversation again. Crystal clear. The dishonesty conviction part does not require you spend a single day in jail. That is how serious the drafters of the Constitution saw a dishonesty conviction, that they wanted to preclude anyone with a dishonesty conviction from ever running for public office. So even if you didn't go to jail, this clearly states has been convicted by any court anywhere in the world. Timbuktu, Saskatchewan, it don't matter. You're not coming back to Cayman with a dishonesty conviction and running for public office. No, not going to happen. So this was the section under which Mario Rankin's disqualification was being questioned. And they say in paragraph 8, let me fast forward the slide. Y'all can read it, kind of read it for yourself, I think. It is significant to be examined. It is of significance to be examined below that this phrase, which I shall by convenient shorthand called the dishonesty disqualification, was introduced as such for the first time on November the 6th, 2009, when the Constitution came into effect. Prior to November the 6th, 2009, and while capital punishment was still part of the Cayman Islands law, criminality-based disqualification was prescribed for in Section 19(1)(e) of the 1972 Constitution. Okay, let's fast forward. These are some of the points that were brought up in this case. Again, if y'all need a copy of it, I'm happy to send you a copy. Okay? While the respondent has not been subject to any term of imprisonment as long as 12 months for either of his two offenses of dishonesty, more than one, we're not surprised. The Solicitor General submits that these provisions, which I should call the imprisonment disqualification, are clearly meant to be both retrospective and prospective, and lend support to the view that the dishonesty disqualification expressed similarly in the past tense, because it says has been convicted. It's also meant to be retrospective in respective dishonesty convictions occurring before November the 6th, 2009. So his lawyer, Mr. Hampson, on behalf of the respondent, argues to the contrary. He relies on the well-established principle recently reaffirmed by the United Kingdom Supreme Court that a statute shall not be construed as retrospective in operation unless such a constitution appears expressly in the words of the statute or arises therefrom by necessary implication. So in other words, this provision came into effect in 2009 in that constitution. The conviction was way before that. Does it still apply? Well, the courts found yes. Let's scroll forward to the judgment. Let's just keep going. It's a very interesting case and you guys should read it. Like I said, it's only 22 pages. So has multiple convictions for dishonesty. I think they were something to do with theft. I think actually some vehicles or cars or something was involved. They talk about the procedural issues, sufficient evidence. Okay, so that goes into quite a bit of detail there. And we need to we can just fast forward and get to the crux of the matter, the decision. Okay, let's keep scrolling. Analysis by the learned judges. And then we get now to blah, 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 blah. Let me see now. Where does it conclude? Analysis, page 18. Paragraph 57 says that it is, as already noted above, there's no question but that the respondent's conviction of dishonesty are to be regarded as spent. So yeah, he applied and have it spent. He can get a clean police record. And that he acquired the status of a rehabilitated person, generally for all purposes in law as stipulated in section 4 of the 1998 law before the 6th of November 2009. And so therefore the Constitution, before the Constitution came into effect. And as follows, therefore, in keeping with section 50 of the CRSC law, that his rehabilitated status continues unaffected and undiminished. Okay. But as also noted above, this does not mean that the opportunate rights and benefits of rehabilitation were ever or will ever be unlimited. This is what I'm saying. It's a limited right. Even when you go to court, there's another limitation there. The court will hear about your spent conviction no matter when it was. It goes on to say, indeed, the legislative policies of both the 1998 law and the CRSC law are based on a philosophy that recognizes that while rehabilitated persons must be allowed to overcome past delinquencies for which they have atoned, there are competing public interests of such importance that these interests will continue to require the disclosure and citation of otherwise spent convictions or expunged records. Like I said, it's not for everything. Yeah? If you keep reading, they talk about earlier provisions regarding the sentence of imprisonment for 12 months. Disqualification is one which can neither avoid nor attenuated by the rehabilitation effect of a relevant conviction or sentence having become spent or expunged from the records. In other words, for the purposes of a disqualification by operation of law, a spent conviction, this is section 63, this is the crux of the matter, a spent conviction does not result in a disqualification also becoming spent. And this was so even under the 1998 law. And they talk about that law. Thus, the policy of the legislation. I got a call coming in here. Good morning, caller. Welcome to the program. Hello? Hi, caller. You're on air. Can I help? Okay. I guess he didn't want to be on air. The former is intended for the protection of the redeemed offender, the latter for the protection of the wider general public, right? The rights and benefits acquired by dint of rehabilitation do not include a right to avoid a limitation of disqualification imposed by operation of law. It's very, very clear. Although the dishonesty disqualification was not in operation during the respondent's period of rehabilitation, his rehabilitation was always subject to limitations by a disqualification imposed by operation of law. Okay. Accordingly, In my view, no real question arises out of the Constitution operating retrospectively so as to infringe a vested interest of the respondent. The respondent never had a right to avoid a disqualification which exists by operation of law, here by operation of the Constitution as the supreme law, simply on the basis of his convictions having been spent. Do we need to go any further, or is it crystal clear? It is a disqualification which certainly limits his rehabilitation in the sense that he is denied that opportunity of other citizens to seek elected office. But that is an inevitable consequence of the philosophy and operation of the legislative regime as it has stood from the beginning and still stands. He was found to not be eligible to run for elected office. So anybody else who has a spent conviction, specific, let me be very, very clear, to the offense of dishonesty, you cannot run for public office. I don't care how many clear certificates you show. Let's put that to bed. Leave it alone. There are many other ways in which you can contribute to the good Cayman Islands. Find your niche. It's just not going to be as an MP. All right. Morning, Ja, Rover. Cameron says Sandy can really be up on her feelings, though. I just telling y'all the facts, laying it out by law. Cameron says brick by brick, we got to take him down. We're becoming and too marginalized. I think I read that one already. Good morning, Miss Sue. 8 years only, that it for Parliament. Jonathan says Cayman simply does not need or should need want anyone convicted of a criminal offense involving dishonesty. That is why it is a preclusion forever for that particular offense. It is the only offense specifically mentioned in the Constitution. I want y'all to think about this, right? Technically, you could be convicted of some sort of manslaughter, murder, taking somebody's life. And if you don't get a sentence of more than 12 months, you could still be an MP. But dishonesty was seen as so pivotal, and we know why when you look at our MPs, as to the caliber of what we're seeking to put in that so-called honorable house. It is the singular category of offenses that is named that will preclude you from ever representing the people of Cayman Islands. They don't care if it was 10 years ago, 25 years ago, or even 50 years ago. Because as we know, most people who have demonstrated and been convicted of a dishonesty offense, that is part of their core personality. I'm not saying people can't be rehabilitated, but the legislators obviously felt that it was so important that it should never, ever give you an opportunity to serve. Sunita says the next election is going to be interesting. We need all new people to help stop corruption and help locals get jobs and stop the permits scourge. People vote wisely. Again, the permit scourge isn't your major concern, but we do need a couple changes around the place. Hi, Cindy is here. Marshall says, who's going to vote for Carrie if she decides to run? What is it she's bringing to the table? She better don't waste her money that she needs. Again, she's running in the BRAC. Doesn't take much to get elected to the BRAC in any event. But the bottom line really is, unfortunately, she's not eligible. The decision is crystal clear. The law is crystal clear. And so it is what it is. I don't make up the law. I didn't write the Constitution, but you have to have a degree of understanding. So I would suggest there's a case on it. Some areas there might not be case law and you figure, okay, I can make an argument. I can kind of work it. There's case law specifically on this, a spent conviction for dishonesty. Mario Rankin was found to not be eligible. He was disqualified, and Carrie would be found to be disqualified as well. So, nothing to get upset about. You just have to accept what it is. Miss Brenda says, good morning, Sandra. When employees don't pay pension insurance for their employees, is that also dishonest? In your opinion, should they be eligible to hold office? Well, it's not considered in law a dishonesty offense because of the way the pensions law is written. Many judges have said that in their opinion, it is a form of theft and it should be treated as such. Miss Brenda, what that requires is the legislators to go back to the drawing books and make it crystal clear that it is theft. By them hiding it into the pension and health insurance law as a separate offense, it's dishonest for sure, but it's not being categorized as such. They need to fix it. Father God, please help anybody that ever fallen out of foul with Auntie Sandy ever. This isn't anything about that. This is about people sending me the stuff over the weekend saying, hey, Sandy, what's the legal position here? And so we have talked about it before in this program. I felt I had a proper obligation to explain to you why I've said the things that I've said. Like I said, I don't know who she's planning on suing, but I know it can't be me because I'm only spitting facts left, right, and center. The facts are the facts. And again, don't put yourself in a situation where you don't understand what the law says and how it applies to you because you're making these public statements. So Nita says politicians' jobs are the only jobs that exempt and protection in Cayman. All other jobs up for grabs. No, their jobs up for grabs too. It's just that they're only up for grabs once every 4 years. But their jobs up for grab, and some of them we need to grab them. We just need better than what's there. It don't make no sense to replace them with something worse. So how can anyone travel after convicted for drug offense? Well, again, if you get your conviction spent for the purposes of travel, that might be okay. You might be able to get, rights to be able to travel and so on. But spent convictions have limitations. That's the bottom line. All right, good folks. Just wanted to clarify, those fine points. I think that they need to change it, Ms. Brenda, without a doubt. One of many pieces of legislation that needs to be amended. Okay, so that's it. If you want a copy of that case law, by all means, let me get it to you. I don't have a problem sharing it. Knowledge is power. And the knowledge is meant to be shared. It's not meant to be hidden from people. It's not meant to, I'm going to keep all the knowledge in my head because somehow that makes me more valuable. Nobody have it. No. We're here to share the knowledge with everybody. It's just a question of whether you want it or not. Left, right, and center, we will share the information.